just want to welcome you all here tonight. Obviously, a lot of us have some concerns about, well, a lot of concerns about what's going on, what the government's doing, and the rights that they're impinging on for all of us. So tonight we'll have Darren Dixon and DARRYL O'Bryan to speak to you. Some of you may have been listening to them already over the last few days in their workshop in the Know Your Rights, but this is a bit different. Get a little bit more information tonight. Okay, now when you came in, you all would have received one of these as your little ticket. This is the disclaimer regarding the information tonight, so please read it. It's important that you read it and understand it. I want to introduce Darren Dixon. And Darren, I'm just going to say a few little things about him that he told me just today at lunch. So Darren's had 15 years studying the law. So he's also a specialist in research and education on the Crown, the Constitution and property law, which is what he'll be talking about tonight. He'll also be talking about the voice, the King, and the Constitution. Now, I was listening to John Anderson today, and John Anderson, you may know, is a former Deputy PM, and I really liked what he said, and I just want to say this to you. This is about the voice. And he is very knowledgeable. He says we have to be suspicious now. The voice, in its current form, lacks detail, lacks answers, and has no transparency. And they are creating a separatist movement. I think we really need to take that to heart and strongly come out against the voice. It's not that we don't want everything to be equal between us, but we can't have it being done this way. Okay, so Darren is also the founder of Constitution Watch, and he appears on other platforms such as Tom Barnett's Living Free Lawful Me, which I'm sure most of you know about. And he also is a special guest for the Know Your Rights groups. And both Darren and DARRYL have travelled around the country repeatedly, I think, on a very, very high turnover of giving seminars and education to people. So on that, I'm going to welcome, I'll stop waffling, I'm going to welcome Darren to the podium. Take it away, Darren.
Good evening, everybody. Thank you for attending. We really appreciate it. We didn't expect so many people in the room, so it's great to see a good turnout and people in support of what's going on in this country at the moment. So what I want to talk to you about first is the voice referendum. And specifically what I want to talk about is the discrimination that's being raised by the Commonwealth Government, and they're trying to make you feel as if you're a racist because you have actually, or that you might vote no in the referendum. Now, the referendum itself is going to change the face of the Constitution. It's going to create a two-tier system for different races, an apartheid, if you will. So what we need to do is, well, I can't tell you how to vote, but I know I'd be voting no. I have a little video clip that I want you to watch because it basically shows you who is behind the voice and what it is actually all about and what the foundations and the roots of the voice actually are. And I think you'll be quite shocked. So let's have a look at this video. It's only a 90-second video.
The people who stand with me on the stage I regard as giants.
Thomas Mayo. Handbook called the Voice of Parliament Handbook. all the detail you need.
Thomas Mayo is a signatory to the Uluru Statement from Perth, but was also entrusted with the physical document.
Mayo is part of the referendum working group.
He spent 18 months travelling around Australia to garner support for an Indigenous voice to Parliament.
And I tell you what, we are sick of governments not listening to our voice. We are going to use the rule book of the nation to post them.
There is nothing more powerful than building a First Nations voice, a black institution, a black political force to be reckoned with.
Keep going until we change the system, until we tear down the institutions that harm our people.
And also to pay respects to the elders of the Communist Party, who I think, without a doubt, have played a very important role in our advocacy. You know, this is the first step. It's a vital step. Pay the rent, for example. You know, how do we do that in a way that is transparent and that actually sees reparations and compensation to Aboriginal and Torres Strait Islander people?
The power in the voice is that it creates the ability for First Nations to go forward with coherent positions on what legislation needs to be created, what legislation needs to be amended, and punish politicians that ignore our advice.
So, as you can see, there's a lot more behind the voice than what you're aware of. The voice is backed by communist militant groups. These people want to change our constitution so that there is a second government in place inside the constitution, inside our parliament. The government are not telling you what the changes will be, because the changes will create this two-tiered system of racial discrimination. So basically there will be one or two races of people that will have more rights in this country than all the other races. It doesn't matter which race it is, okay? We do not live in a system that encourages that type of system. We all need to look at what's going on, and we all need to act accordingly, because this will change your life forever. You're aware of the Aboriginal Heritage Act, or the bill, should I say? Well, luckily that's been stopped, but this is going to happen all over the country. It's going to create a system of government or a system of governance that oversees your land and oversees your daily life. It will affect everyone, and it will not be able to be removed because it will be enshrined in the Constitution. Section 51 of the Constitution is where all the lawmaking powers are found, and Section 51(26), there is a lawmaking power that the Parliament have a special power to write laws for special races. The power already exists in the Constitution for the government to write laws for the Aboriginal people. So why the referendum if the power already exists? And I'm not sure if you heard, Anthony Albanese is now talking about that if the referendum is not successful, that he will use that power. So you've got to think to yourself and wonder, why do we have to change the Constitution if the power already exists, and that he will do that? So one thing you're being told, as I mentioned earlier, is that you are a racist if you vote against the voice. It's actually the other way around. I'm going to show you a document now, and this will show you that the real racists are the government that are enacting these laws. So we're going to look at the International International Convention on the Elimination of All Forms of Racial Discrimination. Now, this is a treaty that Australia entered into in 1969, and then it was ratified into law in the Racial Discrimination Act of 1975 in the schedule. So we're going to look at parts of it, and we're going to, well, I'm going to get you to decide on whether you're the racist or whether the government are the racists, and they're actually in conflict with this treaty that they've actually signed on to. So the treaty is to promote and encourage universal respect for and observation of human rights and fundamental freedoms for all, without distinction as to race, sex, language, or religion. Considering that the Universal Declaration on Human Rights proclaims that all human beings are born free and equal in dignity and rights, and that everyone is entitled to all the rights and freedoms set out therein, without distinction of any kind, in particular as to race, colour, or national origin. So the Voice is in conflict with this straight away. They're trying to enact legislation and change the Constitution so that they will not have to abide by this treaty that they've already ratified into law. So it's also to reaffirm that discrimination between human beings on the grounds of race, colour, or ethnic origin is an obstacle to friendly and peaceful relations among nations and is capable of disturbing peace and security amongst peoples and the harmony of persons living side by side, even within one and the same state. Convinced that the existence of racial barriers is repugnant to the ideas of any human society. Alarmed by manifestations of racial discrimination still in evidence in some areas of the world and by governmental policies based on racial superiority or hatred, such as policies of apartheid, segregation, or separation. And that's exactly what will occur if you vote yes to the Voice. Resolved to adopt all necessary measures for speedily eliminating racial discrimination in all its forms and manifestations, and to prevent and combat racist doctrines and practices in order to promote understanding between races and to build an international community free from all forms of racial segregation and racial discrimination. So that was the preamble to the treaty. Now we're going to look at the actual treaty itself, the articles. So Article 1 clearly states, in this convention, the term racial discrimination shall mean any distinction, exclusion, restriction, or preference based on race, colour, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on any equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of public life. Special measures have been taken for the sole purpose of securing adequate advancement of certain racial or ethnic groups or individuals requiring such protection as may be necessary in order to ensure such groups or individuals equal enjoyment or exercise of human rights and fundamental freedoms shall not be deemed racial discrimination, provided, however, that such measures do not, as a consequence, lead to the maintenance of separate rights for different racial groups, and that they shall not be continued after the objectives for which they were taken to have been achieved. So the state parties must condemn racial discrimination and undertake to pursue by all appropriate means and without delay a policy of eliminating racial discrimination in all its forms and promoting understanding among all races, and to this end, each state party undertakes to engage in no act or practice of racial discrimination against persons, groups of persons, or institutions, and to ensure that all public authorities and public institutions, national and local, shall act in conformity with this obligation. So the state government and the local government have the obligation also. Each state party undertakes not to sponsor, defend, or support racial discrimination by any persons or organisations. Each state party shall take effective measures to review governmental, national, and local policies and to amend, rescind, or nullify any laws and regulations which have the effect of creating or perpetuating racial discrimination wherever it exists. So they have an obligation to scour the laws and remove anything that is racist. Now, I know many Aboriginals, and most Aboriginals are opposed to this. And there's been a new term that's been coined recently. It's called corporate Aboriginals. And these people are the people that are basically wanting to take back the land and basically saying that we must pay the rent for that land. They are claiming ownership over that land. Now, if you talk to any genuine Aboriginals, you will know that they consider themselves the custodians of this land, and they are to keep the land for the next generation. There is not a concept of ownership in Aboriginal law or in Aboriginal culture. The term ownership is a Western term. The British bought that term here. And of course, as you already know, it is the Crown that owns all the land here, allegedly, and they sell it off. This concept of ownership is foreign to Aboriginals. They are simply taking care of the land for you, for me, for their children, and is to pass on for each generation. There is no concept of ownership. So each state party shall prohibit and bring to an end by all appropriate means, including legislation as required by circumstances, racial discrimination by any persons, groups or organisations. Each state party undertakes to encourage, where appropriate, intergenerationist, multicultural organisations and movements and other means of eliminating barriers between races and to discourage anything which tends to strengthen racial division. This racial division is what the Voice is going to create. I'm not sure if you've seen, but there's going to be various rules and laws which give the Aboriginal and Torres Strait Islanders more privileges than you throughout the law, which creates that two-tier racial system. So Article 3, state parties particularly condemn racial segregation and apartheid and undertake to prevent, prohibit and eradicate all practices of this nature in territories under their jurisdiction. State parties condemn all propaganda and all organisations which are based on ideas or theories of superiority of one race or group of persons of one colour or ethnic origin, or which attempt to justify or promote racial hatred and discrimination in any form and undertake to adopt immediately and positive measures designed to eradicate all incitement to or acts of such discrimination and, to this end, with due regard to the principles embodied in the Universal Declaration of Human Rights and the rights expressly set forth in Article 5 of this Convention. They shall declare an offence punishable by law all dissemination of ideas based on racial superiority or hatred, incitement to racial discrimination, as well as all acts of violence or incitement to such acts against any race or group of persons or another colour or ethnic origin, and also the provisions of any assistance to racist activities, including the financing thereof. They shall not permit public authorities or public institutions, national or local, to promote or incite racial discrimination. Article 6, the state parties shall assure to everyone within their jurisdiction effective protection and remedies through the competent national tribunals and other state institutions against any acts of racial discrimination which violates his human rights and fundamental freedoms contrary to this convention, as well as the right to seek from such tribunals just and adequate reparation or satisfaction for any damage suffered as a result of such discrimination. So, as you can see, it's not you who is racist. By voting no, you vote for equality. You vote that every race in this nation is on an even standing. You will vote for the continued lifestyle that you currently enjoy. So if you are going to vote in the Voice referendum, you need to consider that it is actually the Australian government and the Western Australian Parliament that were trying to impose racial segregations upon you and trying to give one particular race an advantage over your particular race. Is that something that we want to live with, everyone? No. So you need to spread this far and wide. This is a communist-backed agenda. The people who are behind this have been behind this for decades, right back to the 1967 referendum, where they actually removed the Aboriginal references out of the Constitution. And ever since then, they've been using these communist agendas, which is to use the indigenous of each country as a way to break down the Constitution and the lifestyle of that particular country. So next time you're speaking with someone and they're telling you that you're racist because you're going to vote no in the referendum, you can clearly be able to educate these people now that it's actually the government that are the racists. So what we're going to do now is I'm going to look at a few different things in regards to the Constitution, because I was asked to come here and speak about the Constitution. We're going to have a little crash course, and we're going to speak about just a couple of sections of the Constitution. So what we're going to look at is Clause 2 of the Constitution, which is in regards to the Queen. And Queen Victoria was the original Queen when the Constitution was enacted. And the Act is an act to extend to the Queen's successors. And the provision says, the provisions of this Act referring to the Queen shall extend to Her Majesty's heirs and successors in the sovereignty of the United Kingdom. So what does that mean exactly? Well, the Queen in the Constitution is the Queen of the United Kingdom within the sovereignty of the United Kingdom. There's a second clause in the Constitution, Clause 5, that we're going to look at as well. And this dictates the operation of the Constitution and all of the laws. And it is this Act and all laws made by the Parliament of the Commonwealth under the Constitution shall be binding on all the courts, judges and people of every state and every part of the Commonwealth, notwithstanding anything in the laws of any state. So what that effectively means is the Constitution is binding on you, me, the courts, the judges of every part of the Commonwealth and within every state. This also means that this particular provision in regards to the Queen in the sovereignty of the United Kingdom is also binding upon you. So we're going to look at the breakdown of Clause 5, especially the phrase "and all laws." So no difficulty is suggested by the words "and all laws made by the Parliament of the Commonwealth under the Constitution." The words "under the Constitution" are words of limitation and qualification. Not all enactments purporting to be laws made by the Parliament are binding, but laws made under, in pursuance of, and within the authority conferred by the Constitution, and those only are binding on all the courts, judges and people. A law in excess of authority conferred by the Constitution is no law. It is wholly void and inoperative. It confers no rights, it imposes no duties, it affords no protection. So what they're telling you there, this is from the annotated Constitution. What they're telling you there is there's two types of laws in this country. There's the ones made under the Constitution, so within the lawmaking powers, and then there's laws that are not, and those laws are not binding upon you. So let's look at a law that could possibly be one of those laws. There's an act, and it's called the Royal Styles and Titles Act of 1973. And this act actually creates the title of the Queen. So what it actually is there is no Queen of Australia or King of Australia, because it's simply an adopted title that's been created in an act for the Queen to adopt for use in relation to this nation. So let's read it. So whereas in accordance with the Royal Styles and Titles Act 1953, Her Majesty by proclamation adopted as the royal style and title to be used in relation to the Commonwealth of Australia and its territories. So that was in relation to the 1953 title that the Queen adopted when she first became the Queen. And the second part is, and whereas the Government of Australia considers it desirable to propose to Her Majesty a change in the form of the Royal Styles and Titles to be used in relation to Australia and its territories, the assent of the Parliament is hereby given to the adoption by Her Majesty for use in relation to Australia and its territories in lieu of the style and title set forth to the schedule of that Act. In lieu of means instead of. Now, can anybody see any anomalies in this? Because I read this a lot of times before I saw this particular anomaly. In the first paragraph, you will see that it is a title that's adopted to be used in relation to the Commonwealth of Australia and its territories. And down here, we have the second title to the adoption by Her Majesty for use in relation to Australia and its territories. Up here, the Commonwealth. Down here, no Commonwealth. So what's the Commonwealth? The Commonwealth is a political union of the states, the people of the states united in one federal indissoluble Commonwealth. It is the body politic, the entity, us. It's all about us. So in 1953, the Queen adopted the title for that Commonwealth, for the body politic, the political entity. But down here, she adopted the title in relation to Australia and its territories, which is a geographical location. And this is backed up by the Interpretation Act of the Commonwealth. So now the title only applies to the landmass. It's word art, and what they did was they removed the Commonwealth. There was a silent revolution where they changed the power and authority from the Queen in the sovereignty of the United Kingdom to the Queen of Australia, to the Queen in the sovereignty of Australia. And they didn't tell anyone. Because in 1953, I've gone and looked at the archives, the Australian archives, and when the Queen adopted her new title in 1953, every single newspaper published it. The nation was proud. We had a new Queen and a new title. And in 1973, in the archives, there is not one thing to be found. The government was silent when they did this. So let's look at what an enumerated power is. So in the Constitution, there's these things called the enumerated powers. Enumerated means numbered powers. And in section 51, there's 39 lawmaking powers. And that's fundamentally the powers of the Commonwealth. There's a couple in a few other places, but we'll focus on the 39. So the legal dictionary says that Legislative power conferred expressly by and subject to a statute, usually a constitution. The Commonwealth's enumerated powers are subject to the Commonwealth Constitution as a whole, including the express and implied limitations on legislative power. These powers are primarily found in the Constitution at section 51, but also in the Commonwealth Constitution in 52, 67, 77, 78, 96, and it's actually 121, 2 and 3. So there's also a thing called the enumerated powers doctrine. And it is a doctrine that where the Commonwealth seeks to support the validity of its legislation, it is necessary for the Commonwealth to point to enumerated power to give to it to point to an enumerated power given to it in the Commonwealth Constitution. So when you want to validate your law, the Commonwealth must point to that power. This particular act relies on this particular power, and that's why we've enacted it. So this is a Freedom of Information response, and this is from 2004. And it was written by a man who lives right here in Perth, Neil Pitchinen. And he asked specifically, he asked and requested the instrument that the Royal Size and Titles Act of 1973 looks to for its head of power under the Constitution for its valid creation by the Commonwealth Parliament, or a lawfully valid instrument outside those powers and out in section 51 of the Constitution. If you have a look down the bottom here, you will see that it does not exist. So there is no power to create a title for the Queen in the Constitution. But of course they went ahead and did it anyway. So what did we talk about earlier? That there are pretended laws in this country. And it's the laws that are not made under the Constitution where you can point to that valid head of power for the creation of that law and to validate that law. Well, then you cannot validate the law, and the law is not binding upon you. The law is basically invalid. So there's I'll go back one. There's a document from 1988. And it's called the Constitutional Commission Reports of 1988. And it's a commission report that was brought about by the Attorney General's Office of the Commonwealth. And what this particular document does is they put together a commission and they wanted to provide recommendations to the Attorney General's Office of how to update the Constitution. And they created 43 bills to change the Constitution, so to be brought to you at referendum. Now, in 1973, they created that new title for the Queen without a valid head of power. So let's look at Bill number 1. Now, it was a bill for an act to alter the Commonwealth Constitution by omitting obsolete words and so as to recognise the Queen of Australia. Now, this bill was never presented to the electors at referendum and it's never been enacted. Now, this was a bill to recognise the Queen of Australia in the Constitution. So if it's never been enacted, then the Queen in the Constitution is not the Queen of Australia. There was a second bill, a bill for an act to alter the Constitution so as to require senators and members of the House of Representatives to take oaths or affirmations of allegiance to the Queen of Australia. This bill was never presented to you either. And this has never been enacted, and there has been no change in the Constitution for members of the House of Reps and senators to swear oaths of allegiance to the Queen of Australia. Has anybody ever seen the swearing in of particular ministers? They all swear to the Queen of Australia, or now the King. So what does section 42 of the Constitution say? It says every senator and every member of the House of Representatives shall, before taking his seat, make and subscribe before the Governor-General or some person authorised by him an oath or affirmation of allegiance in the form set in the schedule to this Constitution. So you must take the oath of allegiance that's found in the schedule. Let's look at the schedule. It says, I do swear that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors according to law. So help me God. But what I want you to focus on is the note down the bottom, which says the name of the King or Queen of the United Kingdom of Great Britain and Ireland for the time being is to be substituted. So in other words, when the Queen passes, you now substitute the King's name, the King of the United Kingdom. So what does this mean? Well, it means that every senator and every member of the House of Representatives is sitting illegally in the Parliament. They have not sworn allegiance to the correct Queen as prescribed by the Constitution. They're swearing to an alternate Queen that they created without any power to do so. And the effect is the abolition of a lot of rights. So let's look at your Constitution, the Western Australian Constitution. So section 2 says this, the legislature to be constituted in Western Australia. So the Parliament of Western Australia consists of the Queen and the Legislative Council and the Legislative Assembly, the Queen. Every bill after its passage through the Legislative Council and the Assembly shall, subject to section 73, be presented to the Governor for assent by or in the name of the Queen and shall be of no effect unless it has been duly assented to by or in the name of the Queen. Which Queen? See, every law in Western Australia since 1973 has not been assented to in the name of the correct Queen. And what does this say? It says that it shall be of no effect unless it is given the assent under the name of the correct Queen. Now, Rod Cullerton is the only senator that I know that actually swore the correct oath. And he's been bringing this to the attention of members of Parliament. Now, after having these meetings with the members of Parliament, they've withdrawn the bill. So the members of Parliament are very dubious as to whether the acts in Western Australia can actually gain the correct and true royal assent, because if they don't, they shall be of no effect at all. So in the Interpretation Act of Western Australia, it says in this act and every other written law, Her Majesty, His Majesty, Queen, King or Crown means the Sovereign of the United Kingdom, Australia, her other realms and territories, and head of the Commonwealth. So the Queen in the Constitution is the Queen of the United Kingdom. It's not me saying this, it's the Interpretation Act. So does the assent have any effect of the laws that have been enacted since 1973 in Western Australia? No, it'd be fair to say.
So now we have the second part of the show. This is DARRYL O'Bryan, again from the Know Your Rights group. And so those of you who've been listening to DARRYL and Darren the last few days, here for another extension class. So Darryl's going to be speaking on the land titles and the illegality and the encroachment of the digital form of the land titles that are currently being undertaken here in WA and probably elsewhere. Darryl's had 22 years of conducting public meetings on the Constitution, and he formed the Community Law Resources Group. He's also an expert on Corhaden. Now, that does sound like it's not an L, I know. For those of you who are familiar with leaks and the Welsh will know that that is two L's. So Corhaden is, Darryl is the public spokesperson for that organisation. So he'll also be speaking about the certificates of land ownership, the privatisation of the Land Titles Office, and he knows all about the Crown and its relationship to common law. So I hand you over to Darryl O'Bryan. And please keep your questions until after again. Okay, thank you.
Thank you to the good people of this wonderful city, Perth, for coming out and listening to what we have to present. First of all, I guess there's a bit of a disclaimer there. What I'm about to show you is a PDF that was put together by a conveyancer of land in Victoria. And there was a group of these land conveyancers who were quite concerned about what the Victorian government was going to do with relation to the certificates of title to your land. So this is his presentation, but I feel it's important for us to see what was occurring, at least in Victoria, back around between 2011 and 2018, because this was started in Queensland, this change to our land title system, and it slowly crept through each of the eastern states and, of course, Western Australia. We're now all encompassed in this new privatised form of land title recognition. So this is the sort of introduction. As a licensed conveyancer from Victoria with over 25 years in the property and conveyancing industry, I've run and operated my own conveyancing practice in the outer east of Melbourne since 2009. The Victorian government intends to take control of all paper titles currently in circulation in Victoria. This has already been done in other states of Australia, including New South Wales, Queensland, ACT and South Australia. In Victoria, we currently have the option to obtain a paper title. Once abolished, though, the Victorian government can take control of your title. So a quick history of titles. Crown land is the land that is held by the government. Selection of Crown land began in Victoria in around 1860. Once the land has been sold, i.e. alienated, it passes to private ownership. Land that has not been alienated remains Crown land. And of course, the government can convert that at any stage and make it saleable, make it freehold land. So freehold land is the land that's alienated from the Crown, sold by the government and granted to another individual or other entity. Under the general law system, land ownership was based on a set of deeds, so it was a chain of titles, which traced the history of the ownership. Title was proven by producing the collection of deeds which had been held by successive owners, eventually all held by the person now appearing to be the owner. Every time land changed hands, the chain of deeds needed to be produced and a new transfer deed needed to be drawn up by lawyers. This process added to the record of deeds, which was kept by the owner, resulting in an ever-increasing collection of ownership documentations. There was risk of deeds being lost or destroyed, so land ownership in the general law system was not and is not guaranteed by the government. A system of recording and registering land ownership was introduced in Victoria under the Real Property Act and subsequently the Transfer of Land Act. This was known as the Torrens system. So essentially it was around 1862 when the Torrens system centralised with a registry in each state. Its purpose essentially was to introduce and maintain a single register of information about land in private ownership. Under this system, the state government took control of land registration and guaranteed title ownership in the Torrens Land Register, historically known as a register book. It's also known as a ledger. It's also known as an asset ledger. So in English law, that asset ledger was a way and a means for government to raise what's called bills of exchange and for the purposes of funding public infrastructure. So the Torrens system, with its one title and government guarantee, created an original title which was held securely and permanently in the land register, and a duplicate title was then issued to the owner or the proprietor. So at all times, the original parchment was in the possession of the Land Registry Office, and the Registrar General of that office oversaw the security of that title and made sure that any changes made to that title were with the consent of the proprietor. The Registrar of Titles under the provisions of Section 5(1) of the Transfer of Land Act is responsible for registration and management of land titles in Victoria under that Torrens system. Land titles in paper format were not digitally converted, were updated by endorsement on paper land titles through the registration of land transaction up until 2002. So electronic conveyancing was introduced in Victoria in 2013. Electronic conveyancing was not well received. So the Victorian government mandated it in 2018. Now, is that government for the people? No, it's not. And in particular when it comes to land ownership, because the government essentially through the UK system of law came about as a result of landowners getting together and recognising one particular form of governance that they all were in unison to support. And that's still essentially the basic system that we've inherited here in Australia. So the landowners form that foundation that governments rely upon in order to survive. And now they're undermining their own foundation. But they're undermining that foundation because you, the landowners, haven't been told this stuff. And it's time that you be educated. There should be an education package, I believe, that should exist in every high school with respect to our students coming out of that school getting ready to work in the real world. You know, when it comes to buying a house, please be aware that these laws and this structure, this history exists for that land title ownership to have full knowledge, and very importantly that that proprietor of that land is then aware of their powers and they keep an eye on that system, because essentially the law here in Australia is based on you, the people. You're the highest authority, and that's granted through the Constitution of the Commonwealth in the first three words, whereas the people. It's not whereas the government, it's whereas the people. And as Darren correctly pointed out to us earlier, they've shifted it now to the territories. They've shifted it now to a geographical sense. We're not interested in that. We're interested in government for the people, because it's your parliament, it's your system of government. You need to take control of it. And you do that using administration process. You pull them up on what they operate under every day. So as a conveyancer, I had no option but to use a platform known as the Property Exchange Australia, PEXA, a private commercial enterprise created to facilitate electronic transfer of titles and other title dealings in Victoria and other states. And you've got it here in West Australia. You've got Landgate, but underneath Landgate, the whole digital transfer system is PEXA. I've read the documentation here in West Australia. It's the same. There is currently no competitor to PEXA. It's the only electronic lodgement network operator. And at inception, PEXA was owned by the 4 major banks. Jeez, is that comforting? What the hell are the banks looking? Why are they taking control of our land titles office? What's that all about? It came from the Crown. The grant came from the Crown. It was for the purposes of establishing governance by we the people. And now we've got the banks controlling our land titles. Sorry, I don't see that. I don't see that as lawful. And in fact, as you'll find out later, it is not. So the ARNECC is a regulatory authority that is run by the registrars of each state and territory. The electronic conveyancing national law governs the provisions and operation of electronic titles. With only the one ELNO in operation, PEXA basically has control of the market with little accountability to consumers, not to mention a clear conflict between PEXA and the entities that govern it. So the conversion of paper titles, when electronic conveyancing was introduced, the Victorian government converted all paper titles held by the big 4 banks into electronic titles. In turn, the banks were ordered to destroy the paper titles they held. This conversion then moved on to smaller lenders over time, and currently about 60% of titles are in electronic form. A virtual document located in the cloud. How comfortable are we now about that? How well has the electronic cloud worked for us in the past? So the electronic register consists of around 3.3 million titles. Approximately 1.32 million remain in paper form. Currently, as a licensed conveyancer, I can request a paper title if it is unencumbered. In 2021, consultation was undertaken by the Titles Office to determine the future management of the remaining paper titles. The consultation only engaged stakeholders such as solicitors and conveyancers. I think there's something missing there. It's like the proprietors. How about involving us in this? Seriously, people. So what can you do? So if you live in Victoria, there is still time to let the Registrar of Titles and Planning Minister know, essentially, that you're not happy. Not happy, Jan. Not what Klaus Schwab is trying to promote. No, you're going to lose everything and you're going to be happy. This should matter to you, whether you own your home or not, because this is going to affect everybody. So you can, there's some email addresses there, and again, I'm endorsing what's being said here. Get in contact with your land registry office and say, hang on, what's going on? This is not right. Something is crook and tell a rook. You people haven't been communicating with me. As such, I think you could be in for a bit of strife. So let's have a look at what strife they could actually get themselves into. Land title in fee simple. Are we aware of that term?
Yes.
Good. Can the state registry convert your title? Landowner status. So first we have to establish your status. Proprietor of the estate in fee simple. Now, this comes about through a law created in 1290 called the Statute of Qua Emptors, and that's where the freehold estates in fee simple were granted through the Crown. And that's the foundation law for freehold land throughout the United Kingdom and its dominions and colonies. Offers the description of the coat of arms, and this was part of the requirement as a landowner or proprietor, that you would show your bloodline through the ownership of that property. So that would be in the form of a coat of arms, which usually sat at the front of your castle, be it a humble hut or whatever, and you would sign documents off using a seal, and you would normally also have a crest from that. And on the King's ledger was also a brief description of what part you played in the community. So it was all about community and the role you played, and the fact that you were alive within that system, and that your activities were a bonus to the King's asset ledger and formed part of that foundation for bringing about bills of exchange to fund for infrastructure. So this is fascinating history when we dive right into what this whole system was based upon. So it becomes a right in rem through an inquiry for equitable ascertainment under the Articles of Heir and not of War, which is Admiralty. So at the moment they've got us in war. Okay, and that's through the See of Rome. So proprietor, owner, proprietary rights. Those rights which an owner of property has by virtue of his ownership. That's out of a Dictionary of English Law by Earl Jowett. Proprietary rights includes accordance and satisfaction of the doctrine of seison, S-E-I-S-E-N. Get used to the word, seison. It means to set and to sit in quiet, right to enjoyment. So when you go home, you are protected through what I've just described, through the law. The king cannot enter until you give that king or any of his agents permission. And this is where all the trespass laws come through. Quiet enjoyment. And this has been argued through the courts for hundreds of years, all ruling in favour of the proprietor. Right up until this year, we helped a lady in Sydney who charged 2 police officers for trespass on her property. They wouldn't remove themselves. They said, oh, we've got a right to be here. No, you don't. No, you're on private land. Get off the land. Your invitation has been removed. They didn't, so she charged them with trespass. She won the case. Private prosecution. It works. Works for now. Okay. Land certificate. A document issued by the Land Registry to the proprietor of registered land as proof of ownership of it. One who owns land, in the case of registered law, the registered land, the registered proprietor, is the person entitled to the legal estate and is recorded as such in the proprietorship register. Dealing with title deeds. As to dealing with title deeds, those documents are not chattels. Do you know what a chattel is? Yes. So that's a building or an attachment to that land. So that title deed doesn't form part of, it's not a chattel. This is important. It's not a chattel. The title deed is so closely connected with the land that they will pass on a conveyance of the land without being expressly mentioned. It is part of the land. That deed is as much a part of that land as the trees growing out of it and the grass growing out of it. The property passes out of the vendor to the purchaser simply by the grant of the land itself. As a rule, the estate owner, proprietor, is entitled to possession of the documents relating to the owner's title. So any changes to that title can only take place with the proprietor's informed consent. Note, they cannot make a change to that document. This is the law. Offences. So, via the Crimes Act of each state, the crime of larceny can be applied. Theft and fraud can be applied to any form of destruction or to cancel or obliterate or to conceal the whole or any part of any document of title to lands, including any deed, map, paper or parchment, written or printed, or partly written and partly printed, being or containing evidence of the title, or any part of the title to any real estate, or to any interest in or out of real estate. Straight out of the Law Dictionary. Says pretty clearly. So let's have a look at what the law says here in Australia. And the most powerful is in New South Wales, of course. But this should be found in every state. I'm struggling to find, I found it in Victoria. Queensland was sort of, they've been doing a lot of amending and repealing there. And I'm seeing the same sort of thing here in Western Australia. The thing is, under the Constitution of the Commonwealth, Section 118, full faith and credit must be given to every single act and record throughout Australia, throughout the Commonwealth. So it can be just as well applied here in Western Australia because it speaks volumes of what PEXA and the state government are doing to your land titles. So the Crimes Act 1900 New South Wales, Section 121, verdict or larceny of receiving, verdict of larceny or receiving, where on the trial of the person charged with larceny or any offence, which includes larceny, and also with having unlawfully received the property charged to have been stolen, knowing it to have been stolen, the jury finds especially that the person either stole or unlawfully received such property, and such that they are unable to say which of these offences was committed by the person. Such person shall not by reason thereof be entitled to acquittal, but shall be liable for the sentence for larceny or to the unlawful receiving, whichever of the two offences is subject to the lesser punishment. 156, larceny by clerks or servants. Larceny by clerks or servants. Whosoever being a clerk or servant steals any property belonging to or in the possession of or power of his or her master or employer or any property for which it is being converted or exchanged shall be liable for imprisonment for 10 years. So those employees at PEXA are committing offences. Section 157, embezzlement by clerks or servants. Embezzlement by clerks. I mean, this is directly targeting those who work within the public infrastructure. Now, originally, this came out of the Land Property Act of the United Kingdom. Okay, and they, in the Land Property Act, United Kingdom, which is still law today, they cited the New South Wales Crimes Act. So this is how I'm correlating these laws in New South Wales. And it can be, as I said earlier, applied throughout this country relating to all of the performances of every single land registry office. So whosoever being a clerk or servant fraudulently embezzles either the whole or any part of any property delivered to or received or taken into possession by him or her for and in the name or on the account of his or her master, PEXA, or employer shall be deemed to have stolen the same, although such property was not received into the possession of such a master, otherwise than by the actual possession of such clerk. So by destroying your titles, recreating those titles, they're in breach of these laws. Now, the other law they're in breach of is under fee simple itself. So when you dive into the Property Law Act in each state, very clearly says that any fee that is applicable to that land, so for the purposes of transferring the land from one purchaser to another proprietor, any fee, the beneficiary of that fee must be the Crown. There's the fraud. There's the fraud. Section 20 of the Property Law Act in Queensland, I urge you to have a look at that. It's black and white. It must be repeated in every state. It's throughout the United Kingdom. It's in the Law Property Act there. It's part and parcel of your land. It's part and parcel of that title, because that's where it all comes from. So the laws applicable in the United Kingdom relating to your land is as applicable here as it is there. So estate and fee simple. Only estates in land which are capable of subsisting or being created or conveyed at law are an estate in fee simple. Absolute in possession and a term of years absolute. So it's not a minimum amount. It's not 18 inches deep or 36 inches deep. No, absolute means all the way, okay? That's what absolute means. Other estates, interests and charges in and over land shall take effect as equitable interests. So what we're finding in each state, and we're causing the system to worry at the moment because we're getting conflict in the return of what the registrars are doing. Some cases, the digital title will just have estate fee simple. Oh, hang on. That's no longer an estate in fee simple, it's an estate fee simple. So now it's vulnerable, as you see here, to interests and charges. Okay, and this is where Dan Andrews in Victoria, he's just cranked up a new land tax. 2005, well, the Act's 2005, but he put an amendment in last Christmas of a land tax general. So no longer is the land tax, as it was from 2005, applicable only to commercial or investment properties. It's now general. So it applies to your roof over your head. And they're basing the land tax on the value. Now, what have we seen in the last 20 or 30 years? Prices of our properties going through the roof. Now we're seeing why. Because this will lead to Klaus Schwab's "you will know nothing and you will be happy by 2030." Because they'll tax you off the land and then they'll gladly rent it back to you. Isn't that comforting? So estate in fee simple, and we're getting this conflict. So some titles are saying estate fee simple. So I then get the land proprietors to write back and say, but hang on, the original title said estate in fee simple. Well, what's going on? Oh, that was a mistake, sorry. And they send back another copy, changed copy to estate in fee simple. Fee was applied to property to denote that it had the quality of descending to the heirs. Okay, and this is the key. Of the owner for the time being, if the owner did not dispose of it during the life of the owner. Thus, an office or annuity in fee is one which descends to the heir on the owner's death intestate. The term, however, chiefly of importance, is applied to land estates of inheritance in land being called estates in fee. It's another form of estate vulnerable to be determined by condition as applied as an equitable interest. Condition could be according to law, imposing interest and charges in and over land. The Conveyancing and Law Property Act 1881 UK, Victoria, Section 51, it has been decided in England that the exact statutory phrase must be used in fee is not enough. The word simple was added by the court to the habendum of a disentailing deed. And there's the case. So it must be estate in fee simple. This is the law. So they're shifting. Yes, West Australia, I had a couple of people over the weekend bring me copies of their deeds, and yes, the words estate in fee simple does appear, but there's something else creeping on that page. Where there is a reference on the current title to the proprietor, there is a discrepancy on the current paper and digital titles in the form of the all capital name. John Doe in uppercase. This is their sneaky little trick, hoping you will not, because we've been so used to this all capital name appearing. Okay, so when I've been studying law, like Pip said, 22 years. And one of the manuals that I have in my bookshelf above my computer desk is what's called the Styles Manual. Have we heard of the Styles Manual? So anyone who operates as a CEO or in administration or government, use that Styles Manual. It's sort of their Bible for administration. When I look at the Australian Styles Manual, and I've got the 6th edition at the moment, I don't see any reference to all capital name at all. So we've now got an influence of a foreign power existing on our land titles. And what is it? It's called Capitis Diminutio Maxima in Roman law. Well, here we go. Rome. What's Rome doing here? Well, hang on. There's laws specific here in Australia and has been upheld by our High Court in as late as 2010, saying that the Bill of Rights, 1688, is transcribed law here in Australia. And the Bill of Rights forbids any influence at any level of government from the See of Rome. It forbids it. It's an instruction specifically to those in government. It's an instruction to those in the executive, in the parliament, and in the courts. And it's there, it's been provided in order to protect the people, to protect their land, to protect their rights and their freedoms. This is what makes a Commonwealth such an attractive place to the rest of the world, because the people control the whole system. It's vital. So in Roman law, a diminishing or abridgment of personality, a loss or curtailment of a man's status or aggregate of legal attributes and qualifications following upon certain changes in his civil condition, the highest or most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away all of the rights of citizenship and, in particular, all of your family rights. Rome is dedicated to conquering by splitting the family up. And what have we been exposed to predominantly since 1973? There's this dedication to splitting up the family unit. And the first action of that was the Family Law Act. federal. It stood out like a sore thumb to every other Commonwealth law that had been passed here in Australia. It certainly wasn't empowered through the Constitution of the Commonwealth. And it has been used to break up the family unit. It's something that we need to be aware of in order to raise as a concern to those who are currently representing us in our parliaments. So what and I'm a spokesperson for, as Pip said, is a mob called Cohaddon. And Cohaddon essentially is an office created in 1283 under letters patent by Edward I for the purposes of installing a constable into and in charge of the King's Treasury. And Cohaddon, because it runs under letters patent, which run in perpetuity, it's in the King's court as an advisor. And Cohaddon has the ability, as a Crown office, to essentially bring about governance, but under the laws that bind it through its letters patent and the laws of England. We're not interested in Rome, and that's without argument. We're bound by those laws of England. So our advice, once we get this office happening, and it takes 100 landowners to register on our ledger, and we then hand that up to the House of Lords and let them know we're here, hi, and we're going to be reminding the King and the King's Court of their obligations under the Bill of Rights. Because we're here to protect all of those laws of England, to protect the people's rights within that system of law. Because it's the best we've got at the moment on this planet. Because our opposition is the See of Rome. How well has that been working out for us? Not so well. They've infiltrated every possible part of government. How have they done this? So one of the things, the first thing that Gough Whitlam did in 1973, other than create a new title for the Queen, he signed a treaty called the Unidroit Treaty. Have we heard of that? So the Unidroit Treaty came about, and I urge you to have a look at their website. It's unidroit.org. And in that treaty, it clearly lays out their purpose. They are an intergovernmental committee for the bringing about of public law. So they admit it, front and centre. They're the ones who write the script for all of the member states regarding what laws we should be governed under. It's in black and white. They cover local government. There's a list on their website of where they're influencing our governments. They're taking away our voice. They're a wedge between you and your parliament. And it's foreign. It's under the See of Rome. It's not good. It's not in our favour. The digital system, this new digital title, all comes through Unidroit. All of our politicians are given a script, and that's written by Unidroit. There are 63 member nations. Australia joined on the 20th of March 1973 through the Attorney General's office. The US joined in 1962, just after one of their presidents was knocked off. England joined in 1948. and they target the law-making facility within each government, within each member state. Well, you can look at the treaty. It's under the Department of Foreign Affairs. It's on our public records. Darren did a FOI a couple of years ago with our Attorney General, managed to get 300 pages of documents relating to Unidroit here in Australia. Why aren't you being told this by Channel 9? Where's ABC TV? What's going on, guys? Have you got something to hide? I think they have. This is where the devil is. So once we know where the devil is, when you look at that treaty, it actually says there's an out clause. So we just say, come on, we've had enough. Sorry, we're over this whole process of intergovernmental committees. It's a wedge between me and my parliament. So it is my will that the Attorney General utilises, I think it's Article 21 of the Unidroit Treaty, to say goodbye. Thanks for all the fish, but no more. We've had a gutful. We're now going to take over our parliament and operate it according to the law and what the people's will is. And when you go through that constitution, it's amazing how much power, more than the US. I've read the US constitution. I'm not that impressed with it. But Australia's constitution, wow. You know, it is one powerful document. And I read in one of the referendums that was held in 1915, there was a yes and no case. And they said, imagine the Constitution as just this skeleton hanging in the closet. What the Constitution, or what the framers of the Constitution really intended, was for you, the people, to become aware of that document and put a body on that skeleton. Because then we have the best law on this planet, because it's a people-based system. But what have we been confronted with since 1900? A political party system, especially the Labor government, dedicated to removing bones off that skeleton. And they're about to chop the head off it. So we've got to be proactive. And we have to, the first thing I do is I walk into that voting booth whenever that announcement comes with a Sharpie, not a pencil. Walk in with a texter or a biro or something that's going to leave a permanent mark. And we shouldn't be putting up with this sort of misbehaviour. But in fact, I mean, you could pretty much neutralise in a courtroom this upcoming vote, because when you read section 128 of the Constitution, it says very clearly that the people, when they go to vote at a referendum, must be under what's called suffrage. That's SUFFRAGE. That means a right to vote. Okay, it's your free will to go up and vote. No one should be forcing you. And that's inherited law. It's a law of 1275 in England. It's here imprinted into every state statute. It's here in Western Australia, it's in every single state. No one, the King, cannot force any one of us to take part in an election. And yet we're confronted with compulsory elections. And there was an act passed in 1915 called the Compulsory Voting at Referendums Act. So I don't see a head of power for that. When I look at the Constitution, it doesn't say it's compulsory, it says otherwise. Okay. So it is an important referendum that's coming up. It is something we need to partake in. in order to send that signal hard and fast that we the people have had a gutful. We need to take back control of this country. We first do it by saying no, and then we start sitting down with our members of parliament and say, come on, mate, what's happening here? My land title, something that I've spent most of my life working to attain, so that I can hand that on to my kids or whomever I so please, it's being attacked. When I see what the law says about what your state registries are doing, I see they're committing an offence. So Cohaddon will be there to back you up to say, hey, the Crown is back here in Australia. We don't want to reinvent the wheel. We're just here to remind you, because I mean, it's a logistical nightmare to try and take on all these titles. But we want all these officers to just step back to where they should be. Get back into your paddock and behave. They're only outside because we don't know this stuff. We should know. It's time for us to stand up and do this in an administrative sense. You don't throw stones at these people. You use what's called diplomacy. You go back to them and get them to admit that they're a bunch of crims. And you do it with a smile on your face. This is what I've been doing for 22 years. I've had quite a fair bit of success. You know, I managed to stop 2 toxic waste dumps in Victoria. I stopped the government there from imposing 2 toxic waste dumps. And that was just using your voice. I was using a form I created called a mandate. You know, we've heard that word before, haven't we? And I got the people in those 2 communities to sign a mandate, and it just simply said, it is my will that you, my parliamentarian, in my state parliament, take away any application to create a toxic waste dump in this particular area. It worked. It worked. Within less than a week in the first instance, and in the second instance, it took probably about a month and a half. But they backed off. So your will does work when it is applied properly. And when it is applied through safety in numbers. So when you get together in groups like this to hear people like myself and Darren give you some sort of education, we'll want to see you build on this information and build on it in a way where your voice becomes much bigger, much louder than the government or any of their propaganda machine, because they're now killing us off. Whether we like it or not, this is what's happening, and it's got to stop. We don't throw sticks and stones at them. We use their own process back at them. We do it with a big smile on our face. So have a lovely day, because I know the next election, if you don't do what I'm going to request, you're out the door. But you know what? There's even a power to remove them while they're still in office. It's there in the Constitution. The framers of this Constitution of the Commonwealth, they foresaw all of what we're going through. And they put up those barriers, they put up those restrictions to government in that Constitution. So it's up to us. Pick it up, read it, get to understand it, talk with your neighbours about it, and let's move forward. Don't let them walk all over us. Thank you.
Questions?
Firstly, thank you, Darryl, and thank you, Darren. You guys are a wealth of knowledge. I've followed you for a little while, and know your rights group and a number of others. So thanks for all your determined hard work over the years. One thing is, all of us here, we're just little people, and we all want to do our bit, and we all want to help, and we all want to stand up for our rights. But not having the knowledge amongst us, it's difficult. But forgive me if I'm not suggesting you do anything, but I'd like to know if it's possible to do this. You and there's a number of others around Australia are experts on the Constitution. I see them online all the time. And there's people like Augusto Zimmerman, who's an expert on the Constitution.
Mm-hmm.
And with the knowledge that you guys have, and you've got everything there at your fingertips, can we not get up a private prosecution or a case in court with all the information you have, with all of us sitting here and everywhere around Australia as joining a class action? And I'm sure we'd all be happy to put in something to do that, to correct everything that's happening here.
Oh, absolutely. I've seen, there was a High Court case, probably only about 6-7 years ago, and it was against the ANZ Bank. And the beauty of that case was it was something like 70,000 plaintiffs. And that caused the High Court to sit up straight and behave. Safety in numbers really is the key. And the more people that stand up and say, yeah, we've had a gutful, let's take it to the court. Let's put the court in its jurisdiction. Let's put the blinkers on the court. So these are the questions we're asking. And as a result of that question and the answer that we know that will come, that will serve as an instruction to those in our parliamentary system and the rest of the bureaucracy to back off. And I believe one of those should be to get rid of this uni-joint treaty, first and foremost. Let's recognise the devil in the room and throw him out. And then we can start bringing him back. Next question.
Yeah, thank you very much. It was a very good evening, even though a bit depressing. But I have a specific question because I was at the common law meeting and they said, look, today is the last day you have to put your application in to have the proper title with the crown, not the kangaroo and the emu, blah, blah, blah. And I did that. First email came back, then I found a second one. And guess what? The next day I got an email back. We get back to you in the next 2 working days. I'm still waiting. I don't know how long the days are at Landgate, but it's really interesting. So what do you suggest I would do next? Because it's really, I'm bamboozled because it's a long way to Landgate. And I thought, I have to deal with that. Quite interesting.
Yeah, I think the best thing you can do as landowners is to start communicating with the registrar at Landgate and say, mate, what's going on? How come you've made these changes? And where can you show me evidence of where you have brought me into this conversation you've obviously had with government or whoever, and we know it's PEXA, where is my consent for any of these changes to have taken place to my title? Because when I look at the law, it says you've committed an offence. So it's time to ask these questions of those who are in control of these titles. We're going through history. We've gone from a chain of titles to a central registry within each state, and now we're being confronted with misbehaviour. So we now have to step up to the plate and start communicating with these people and say, right, where's my informed consent? Show me evidence that you have even tried to communicate this to me, the changes you have made. Where have you got permission to destroy these titles? This is as much a part of that land as the tree is. I need to know. This is how we start We ask questions. The questions are going to bring these people down. Force them back into where we can control them.
Hey, mate.
And,
I went to Landgate the other week.
yep.
And I was informed that my property title was a non-issue title since 2001. Now, I didn't even buy the place till 2015. How would you suggest deal with that?
Does that correlate with titles originally created in the state of Western Australia? The old historical documents should be that template for every single title that's created. Doesn't matter whether a farm's subdivided, the template is sitting in each state registry. Where did you obtain permission to make these radical changes? I should look at that. Doesn't matter whether that land was just created last year and the title was created last year. I should be able to look at the parchment that existed back when Western Australia was settled and freehold titles were distributed. I should be able to look at that title and I shouldn't see any differences other than the numbers that are allocated and the address. This is what we need to demand. These original parchments had the correct wording on it. That wording was specific to protect your rights. So we must maintain that. We cannot put up with any changes. I showed you in the PowerPoint. You know, no changes can be made but by your informed consent. We need to stick to that. And if we're not happy, we say, sorry, it's not good enough. We need you to go back to those original parchments, and that's what I want to see on that title. It's as simple as that.
Good evening, Darren. Just out the back here.
Yep.
Very back, if you can see me, right very back.
Oh, yeah.
Up here.
Yep.
You were of Wayne Glue?
I have heard of Sticky, yeah.
Okay, just want to know, he's claimed that he's had some lawful seizures of the land in this country. You got any comments on that?
I'd have to see.
And the validity of it?
Yeah, I'd have to see what he's done. I mean, there's a lot of different interpretations of what the law says. And myself and Darren, when we look at the law, we go into the history of that law, we go into all the possible records around that law, and that then brings us to where we are today in front of you. It's not my interpretation. It's what the Parliament has provided and what the law has provided. So I'd have to look at what Stiggy's done in order to make a comment, really. Next.
Thank you. Hi, Darryl.
Hi.
I was at Landgate last week and I spoke to the registrar for 45 minutes and explaining to him about the overreach of government and why we're so concerned. He seemed to not understand why there were so many people there trying to get their original, a copy of their original title under the Crown. By the end, I sort of broke it down. Like I said, after 45 minutes, what he was saying was that he is the authority. He doesn't answer to anyone, and he makes the choices. I believe, this is what I understood. And I've understood this in court too, that the registrar is the most important person, and I understood that also at the Land Titles Office. I might be wrong, but that was my understanding. And what he said only cemented that for me. And then he also said that he has done it only because he has millions of titles to do every year, and it's just out of ease. And I said, I understood it, but can you understand we need to have something in real paper? So I want to go back and speak to him again, but I'm going to get from you maybe some words to go back.
Yeah, and you're right. One thing that they're not telling you, and that is there's no law that stops you from lifting your title from their registry. So you can lift your title, say, listen, I'm not happy with your performance, which is, all the evidence in the world's there. So I'm taking possession of that, and I'm no longer interested in your office. So this is where sort of Corhaddon was sort of standing up to say, well, bring it over here. But logistically, that is a nightmare. So this is why we're encouraging people to force this system, and it's only numbers, and like you correctly said, wow, this guy's going, why so many people here? Yeah, we want 10, 20, 30 times more people. That's going to force these people to go back to what the law permits. This is how we're going to do this. But one of the mantras that we would like you to promote from Corhaddon, this is coming from Corhaddon, is that we would like to see that land valued in sterling pound. Okay, because the Australian dollar, the dodgy dollar, when it was created in 1966, I don't really see how it complies with the law. It's got worse and worse since 1966. This Federal Reserve-backed currency with Federal Reserve-backed banks, if you could call them that. No, our land being granted through the Crown demands that it be valued in sterling pound. This is how we can bring about a change in currency here in Australia. Step away from this fiat collapsing promise to pay debt note that we get distributed and we work hard for. We need something with substance. So this is what we're promoting. And Corhaddon is dedicated, like what I've just presented to you tonight is the tip of the iceberg of the education that we would like you as landowners and people affected through land ownership is to understand better the intricacies of the law surrounding that property ownership and how you can actually go about reforming a proper structure of governance and a proper structure of banking, because it all falls under this Crown office, that inherited right. And as I said earlier, the Corhaddon was created for the purposes of guarding the King's treasury. Okay? And that office maintained that strict rule over the King's treasury. So we're looking to get support through you, the people, and landowners, but we can talk to our registrar generals in each state and say, hey mate, we've had enough. Do I just lift my title off your register? Is that what it's going to take for you to get back into your paddock and stop this ridiculous deal that you've done with the 4 banks? Certainly not comfortable with that one. So this is a sort of language, and this is a sort of compulsion we have to apply when we start talking with these people. We've had a gutful. It's time to stop. Let's get back to where we should be. Quiet enjoyment of our properties. Another question?
Thanks. Thanks, Darryl and Darren. Up to this point, one of the things that I've seen and heard is that our ultimate protection is under the Constitution.
Yeah.
And the ultimate arbiter on that is the High Court. However, when I've followed anything, the obfuscation that goes on, making us go through every single subservient court, just drives the energy out of people
and more importantly, they run out of funds. So that it seems to me it's a deliberate ploy to try and stop us getting to our ultimate arbiter of the High Court. So how do we get there so that we can get the protection of our wonderful Constitution?
You do it fairly simply. It doesn't matter what court level you start in, but there's what's called a Section 40 uplift. So Section 40 is out of the Judiciary Act, 1903, and it gives you a direct portal to the High Court on either questions of law or the performance of the lower court or a jurisdictional claim or whatever. There's a Section 40 in the Judiciary Act goes for about a page and a half, so there's a fair bit of detail in there. And if you go to any of the databases that have law on there, like the OSLE database, you'll notice in the middle part of the home page it'll have Section 40 uplifts, and if you click on the High Court, it's one of the prominent parts, and the High Court deal with Section 40 applications every day. So that's a quick way into our High Court, and in fact in 1975 they installed Section 77B into the Judiciary Act, which actually gives you the ability to have a jury in the High Court on matters, multiplicity of matters. I believe in the public interest is a way of maybe getting the jury up in the High Court. Although, like I said earlier, when we usually get into the High Court, we put the blinkers on the court and we do it through the Constitution. You know, Section 75 and Section 76 of the Constitution gives us the ability to say to the High Court, well, in this particular case, we're running under Section 76I or 76(2) of the Constitution. So we're specifically looking for your interpretation relating to this question of law out of the Constitution. So it is a path, more direct path to it.
Hi, Darryl.
Hi.
And here.
Oh, where are you? Put your hand up.
Just there.
Ah.
Straight.
Right down there.
Straight.
Thanks, mate.
My question is, if the house is under mortgage, who is entitled to keep the original certificate of title?
Yeah, that's a good question, and something that
Thank you.
I've been bewildered by since looking into property law is to when you go to get a mortgage, for whatever reason, the Registrar General allows the bank to take a copy of the title. Now, my study of property law, the Registrar General should only be applying to the title a caveat. That's all that should be applied. Where did they get the right to take a copy or a duplicate of the title? And why would they possibly do this? And of course, that opened up a Pandora's box for me. And I found myself inside a US Supreme Court case where this all came out. And it turns out it comes under what's called securitisation. And securitisation essentially means that usually within about a week of the mortgage documents being approved, the title is then sold to a company called Mortgage-Backed Securities based in New York. And then they trade that as an instrument of title, as a form of currency on the derivatives market. They apply an insurance policy against it. They do all sorts of things. They create another bank account out of it. And it essentially then falls within the category of another company called the Depository Trust Clearing Company, another company called the Depository Trust Company, and then at the head of the pyramid is this company called CEDE Company. And they're based in Bern, Switzerland. They work out of the Bank of International Settlements. and they work out of one office. And that office is called the Universal Postal Union. So we're going from pillar to post. It's just bizarre what they do with these titles. But essentially they make more money out of that title than you and I could ever imagine. So securitisation is against the law here in Australia, but they do it quite openly. Why? Because you don't know. You don't know. You need to know. It's your title. What the hell's the Registrar General allowing the bank to take these things for? Where's that come from? I don't see that in law. More questions for the Registrar General. We need to put these people on the spot. Ask them these awkward questions. Say, now mate, please go back into your paddock. Stay there. If you're not happy being in that job, I'm sure someone else will put their hand up. It's as simple as that. Another question.
Yes, Darryl. It sounds as though the intention has shifted from establishing the Crown Office with 100 landowners lifting their title and coming over to, and then slowly bringing over more people. That was, I think, some of our understanding.
Yeah.
Whereas you've expressed that it's a logistical nightmare to do that, so it's more about pulling the other officers into line. What then happens to the 100 landowners that shift their title over to you guys? How does that work in relation to the system? And then also, second point, hopefully you can speak to it. I'm just curious, when it comes to the Crown or the King, if he's representing the Crown, when he's notified that this Crown Office has been re-established, where does he stand in relation to the See of Rome and the Roman takeover of life on this planet? Is the Crown happy to see that? Are they one in the same thing? Are they working together? Or is he actually genuinely hoping that we come to senses and start to put to work some of the processes that you're talking about?
The beauty of Cohadden, those first 100 landowners will be there for the purposes of putting life back into Cohadden. Once that's achieved, and once we've notified the House of Lords and we've tried to get recognition of the asset ledger for the purposes of having those 100 land owners' properties revalued in sterling pound. Once that's achieved, and we don't need their permission, by the way, it's just a matter of putting that to the House of Lords. We're then installed, because the letters patent is what we're running under. The King cannot dissolve that. So we then remind the King, we remind the King's Court and all those involved in that court that there are obligations under the Bill of Rights. The Bill of Rights is still law in the United Kingdom throughout the Commonwealth, and as such, we expect that the See of Rome be told to go home. We're not interested. And anyone that has any allegiances to the See of Rome, stage left, exit. We're not here to put up with that. Cohadden's devotion is to the laws of England and to the people under the Crown. It's not necessarily to the King. The King is there to take advice. The King can be misled, for sure, but the office of the Crown is untouchable as such. It's just those who work within that office. And it's up to us, the King's subjects, to say, hey mate, stop it, no more. We know now that law. We're here to remind you, and we'll keep reminding you with each generation that if this survives, that your obligation is first and foremost to the people and to maintain our rights. Because if you're not interested in doing that, then we'll put someone else in there. It's fairly straightforward because the power lies with us. So those first 100 landowners, they can rest assured that they're in a safety zone. Because I'm in control of that email. I've probably got about 350 plus titles. on that email. I'm not going to let it go to anybody, okay, until each landowner is informed of what step I'm about to take. And I'm happy with the paperwork that will be drafted to send to the House of Lords, and only when I'm happy, Darren is happy, and people we trust, only then will that paperwork go. It's not about making money, and unfortunately one of the members of Corhaddon is now promoting through this thing called the Royal Registry a fee for bringing that title over. I've never approved that fee. I never would. Darren's in the same boat. He's on that committee. We're not tolerating this as a money-making exercise. It's not. It's not about making money. It's about bringing back this country to the people and to the law, the rule of law. And as the good Professor Zimmerman says, what is the definition of the rule of law? It's law in equity. It must be applied equally amongst every single one of us. Doesn't matter whether you wear a crown, doesn't matter. The law and the rule of law must be applied equally to every single one of us, no matter what we do. And I'll maintain that. I won't budge. I will not let any of those titles slip at all until I'm happy. I know the law. I don't know everything about the law. I'm still learning. I know enough to make sure that that mantra that I just told you of is what I've been maintaining for 22 years. This is why I started teaching the Constitution to the general public, because you are genuinely walking around asleep, not aware of what should be taking place, not aware of your power. This is the only way we're going to take back and survive in the future, is just knowledge. That's my sort of push on to my kids and to whomever I speak to. I hope I'm inspiring you enough to, and Darren, the same mantra, we want to see you start being proactive, take this stuff on board, confirm everything that we've told you, go home, check it out, have a look at it for yourself, interpret it for yourself. And we will keep educating you. We'll put out the education. If you've got questions, ask. We're only a couple of blokes, but we're trying to build a community. And I see what we're doing through Corhaddon as a powerful way of doing that, because COVID hit us hard. And that up to that point, I was only probably speaking to a maximum of 100 people. And it was sort of a little bit disheartening in a sense. But once COVID hit, all of a sudden, we were getting a lot more attention from all manners of our society, every part of our society, doctors, lawyers, people, everyone was being affected. Now it's land titles. And it's great to see a room full of people who are ready and willing to listen, ask questions, and say, hey, what do I do? What do I do? That's what we want. Well, hopefully tonight we've given you enough of a direction to be able to say, okay, geez, all I got to do is ask these questions of these particular administrators. And I think that's, if you can go home with that message and start drafting your question, that's going to have a huge impact. And start joining together, talk to your neighbours, because this is a direct collateral attack on your property. Won't stop at your land. Yeah, next question.
Hi, I have a question. Yeah. In relation to challenging their authority, would it be best to challenge that authority via a Freedom of Information request?
That's one way of doing it. And Darren's website, Constitution Watch, has really got a very good history of FOIs that have been done over the past 5 or 6 years. And that's evidence in and of itself to show then to our local, state and federal members of our parliaments what's going on. This is a reply from the Attorney General. You guys don't have, you don't have authority. What's going on? We need to fix this. So yeah, that's a good point.
Thank you. Hi, Darryl. Very excited to hear some of the stuff you've been saying, because I've been studying the equity and trust law for a couple of years now, in the fight of my life in the appeals court in October against one of the major banks. So that's very exciting. Just want to make one quick comment to the gentleman back there. You were talking about like it gets quite expensive in the courts and whatnot. An act that apparently that someone's been quite successful in using in fighting that is called the Free Access to Courts Act of 1400. So it might be worth looking into that. That's something that I'm definitely interested in. Something you said back in regard to fee simple, you said that any fee that is applicable to the land, the in fee simple land, the beneficiary must be the Crown.
Yep.
And it got me thinking, does this mean that if the councils are collecting fees relating to your land and not giving it to the Crown, then they're actually stealing from it?
When you look at the rates notice, for instance, it's a notice. It's based on a notice to the capitis diminutio maxima. It just has on the notice, it has the folio and volume numbers of the land. It's not actually directly applicable to the land as such. It weaves its way, it makes you think that when you look at the notice itself. And each council is slightly different on how they apply their rates notices, but it is, it originally comes out of the Land Charges Act 1972 UK, the power that they're using to impose rates as such. The High Court found in a couple of cases early in the 20th century that they're not agents of the Crown. So it's not exactly applicable. Specifically, when I used that section of the Property Law Act, that was specifically targeting the state registry officers. So they charge a fee for transfer of land or the application of a caveat or any of that. Now we've got clearly a private group of banks overseeing our registry officers. That is a clear breach. That's fraud. They're obtaining a financial advantage by deception. The deception is that they're operating as the Crown. They're not. So the question, one of the questions we would put to them is, are you agents of the Crown, capable of accepting any fees with relation to my volume and folio number? So, yeah, I hope that's
Thank you.
the question.
Question here, the grant in fee simple, can that be considered, or the originals, were they a contract between Queen Victoria and the landowner? And if they are, then how does the state government insert themselves in between, if it's a contract between two parties?
It was actually the land ownership comes through letters patent of King William IV, which was just the monarch before Queen Victoria. All land was then valued in sterling under silver. The state came into fray into the contract through the Torrens Title and the Real Property Acts. And that was for the purposes of, as I showed you on the PowerPoint, it was for the purposes of correcting the chain of titles. Sometimes you'd get loss or damage. So it was brought into that single registry. But with limited powers, and as I said, I haven't seen a law yet that compels you to stay with that registry. So they have got there, and this is one of the points of education, is to have a look at the Real Property Act in your state, have a look at the Property Law Acts, interpret this for yourself. I've given you the key to the Queensland Property Law Act, Section 20. I want you, it would be a good idea to go home and have a look at the equivalent here in Western Australia. I seem to see this consistency in each state relating to property and fee simple and the estates in fee simple and how it's defined in each state. And it's there. The devil is in that detail. And that devil is going to bring the system back to its knees once we push for it. Another question.
How would you like us to now proceed with Clawhaddon?
Clawhaddon, I'm promoting to people that come onto my, or onto Clawhaddon's email to be patient at the moment. When I'm happy, when Darren's happy, when people that we trust are happy that the documentation that will be served on the House of Lords, once we're happy with that and we've sent that off, we get in contact with the 100 landowners that are on the registry or on that email, and when they're happy to have their details put onto that asset ledger, it's handed up to, and we've done a little bit of study on this, there are 25 members of the House of Lords who have a particular interest in Australia. I mean, there are some 820 odd members of the House of Lords. Once we're happy with the correspondence with them, then we will more or less move on then to inform each of the state governments and federal governments around this country that that office is up and running, whether they like it or not. And we'll also correspond, of course, with the King. So once all of that's in place, we're happy, then we'll go, hopefully by that stage, into a zone where enough of you landowners have put the flag up to your state registries and start pushing them back where they should be. Okay, so I don't trust the Royal Registry at the moment. I don't like the direction that's taken for Clawhaddon. We don't want to damage Clawhaddon in any way for the purposes of just making money. I'm certainly not interested in that. I was first brought into this fray of law when I discovered that the Australian Taxation Office doesn't legally exist, and I was then introduced to a barrister by the name of James Renton, who pulled away from the system because he said Australia's system of governance was completely broken, and he did in law what the law instructed him. He had to go back to the Monash Law Library and study for 25 years, and eventually he found the only way to fix Australia's problem was to annex all of Australia's national estate. And I came into that fray sort of around 2000, and I was part of that public voice to teach you, the people, about that annexation and what it meant. So that the national estate being, because Australia is made up of a series of counties and parishes, as England is as well. And he went through and wrote up an annexation document for each county and parish throughout this country and handed all that paperwork up to Westminster. And they were then put on notice for 7 years. He did that on the 15th of June 1992. 7 years later, there was no response, by the way, from the Queen or the Westminster system or the Australian governments. So 7 years later, what's that? 1999, the last time we had a referendum. So you think that was by coincidence? So Australia technically is under what's called the Principality of Caledonia. That was the name he had to put on the annexation. So unfortunately, there was a Jesuit that moved into that organisation and just destroyed it. So I picked up the pieces and I created the Community Law Resource Group, and here I am today. So I'm using now a proper Crown office, but we need to put that in place, do it properly. No one's rushing. We're going to do it properly. Unfortunately, we've had a couple of hiccups with this Royal Registry, but Darren and I will stand firm because we see the bigger picture. Okay, it's not about making money. This isn't. You know, this is what happened to Caledonia. They got greedy, and it's just no. Money, as we know, is just a debt instrument that leads you nowhere fast. What's the key? Community, friends, getting together. This is what it's all about. Truly is. Yeah.
Oh, hi. I was just wondering, so like past imperial laws, how so obviously they apply now.
Oh yeah, in West Australia you've got about 4.
Yeah, okay. Yeah, so you say in Western Australia, so is that because you got like the 1893 Transfer of Land Act, but that's before the Constitution, so it gets a bit confusing. Yeah, and so how do you know what's an Imperial Act and what is, and how, what law says that it's relevant for an old law to still be relevant now? It's obviously a maxim of law, but can you be specific on it?
Australia was settled through with a system of law, predominantly through one piece of legislation. It was called the Australian Courts Act, 1828. And that established the administration of justice under the laws of England throughout Australia. And you'll find that law is repeated in each state. The imperial laws came about in each state through those imperial laws of England applicable in that particular state, be it for land tenure or for instilling particular parts of English law in that particular state. In 1922, Victoria set about creating, they'd given a job to this gentleman by the name of Leo Cousins. He was given the job back in 1907 to put all of the laws of England into one act. And in 1922, he presented that work to the Victorian Parliament and they passed it into law as the Imperial Acts Application Act 1922. And that is now repeated in every state. In Queensland it's 1984, New South Wales 1969. South Australia have made 4 different adoptions to those imperial laws, but they're all essentially repeated in each state and they're binding on governments. So they're very powerful laws, and that's the beauty of Australia. Where England have repealed a lot of these older laws, they're still enshrined here in Australia. They're one of the only countries in the Commonwealth where that's rock solid, and this is what the High Court ascertained in 2010, and that case was the Port of Portland versus State of Victoria. And a full bench of the High Court said, yeah, we can't touch any of those laws. So they're enshrined and they're there for our use. Wake up to them, use them to our advantage, put these people back in their place. And one of those laws, awkwardly, is sheriffs and lawyers are excluded from sitting in Parliament. Awkward, isn't it? And Ainsley's right, there is another law, it's Henry IV, 1400, freedom of access to your courts. We've used that successfully a number of times around the country. So there's some good laws there. You know, don't throw the baby out with the bathwater, because this system's dedicated to you doing that. They want you to throw it all out. Yeah. Ladies. Oh, yeah.
Sorry.
Thank you very much for you guys for being here, doing so much, including with Rod Cullerton. I must say that we pretty much established that the banks are major problems, and they've been involved since a long time. Prior to COVID, a lot of the other nations, especially Europe, they were going to go bankrupt. They were going to go bankrupt like anything. Obviously, we are in a much better place here, as I understand. But do you think that us, as being a younger nation, we've got a much better chance to pull through what's going on at the moment? Because their system of corruption has not been inflicted as long as it has been in other nations.
Oh, absolutely. Australia is one of the youngest countries in the world. Our body of law is one of the youngest, but we've also inherited access to all of the US Supreme Court precedences to help guide our system of law as we structure it here in Australia. It's essentially only 120 years old since it was federated, and we can take advantage of that, and we're a multicultural society, and we need to use the strength of that multiculturalism to promote, I believe, what will be one of the strongest laws on the planet if we utilise it properly. So it is a vital, good foundation to work off, and it's targeted to the people. So we need to just use it. It's not up to government. Don't expect government to do everything for you. It's up to you. You're the government. You're the true parliament. Do that. Exercise that power. It's amazing. I've proven, I've stopped state government twice from implementing dangerous toxic waste dumps. That's just the tip of the iceberg, guys. You can do so much. You really can. Don't lay down and let them walk all over you.
Can I just add something else? Just because I really think it's very important we don't lose hope.
Yeah.
I remember 22 years ago, there was 11,000 people that marched against the Iraq war. So there's a lot of people that have lost faith in government, but they're not really speaking out. So there's a lot of people to tap into out there, which they know exactly what's going on. Especially even through COVID, that's woken up a lot of people, and now this is waking a lot more people up.
Yeah.
I think it's important we don't lose hope, and we believe that, the other ones will all join up eventually.
Yeah, we've been far too complacent here for too long. Football, meat pies, kangaroos and Holden cars have ruled the roost for too long. So it's time to step up to the plate and do something constructive, for our kids, for our futures, for pretty much everything, because, wow, we're close to that brick wall at the moment. Very close to midnight.
We're going to take one more question from this gentleman down here, and then we're going to wrap up. I'll have a chat with you in a minute.
The question I'd like to ask is there any advantage regarding the titles to track back and get back to the original land grant? Is that going to be of any advantage to us in the long term?
Oh, it will be, because it brings back all those inherited rights under the statute of Qua Emptors, 1290, and the fact that you must, it is an insistence in law that when you go home that you have quiet enjoyment. You shouldn't feel threatened, but also this compels you to also make sure that what you do on your land doesn't impeach upon your neighbour and taking away their quiet enjoyment. So it really brings us back to community, and we've been separated by Rome for too long. It's now time to get back and start taking some of these fences down that the system's put up, start communicating with our neighbours, putting aside all of our differences and honing in on the one common thing that we can all adhere to, and that is the law. And and that's a law that's structured by we the people, not governments, not foreign powers, but we the people. And this is our insurance policy for the future.
I think we need templates. Because there's a lot of information, and if templates turn up into letters,
Yeah.
and they see the consistent message in all these letters, they're going to go hang these people.
Yeah. We will endeavour to create what we can for you. Thank you.
DARRYL O'BRYAN.